9-6 would have rented 1-6.
1916. Okay. Good morning. Are you Patrick Trahan?
Yeah.
And Mr. Trahan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Trahan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Trahan is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
From the state? No. Then at this time, I am going to find that Mr. Trahan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
No, Your Honor.
Now we're going on count one only. I'm the assault on a peace officer.
Yes, Your Honor. We may need to go on both on the staging.
Okay. Hold on a second. Sorry. All right, Mr. Trahan, in cause number 25, DCCR 1917, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer, and that's from November 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And cause number 26, DCCR 0592, you're charged with the state jail felony offense of possession of a controlled substance from March 17th of 2025. And how do you plead to that charge?
Yeah.
Again, are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? Also in that indictment, it alleges that you were previously convicted of the state jail felony offense of theft of copper, bronze, or aluminum, August 11th of 2014. And then after that was final, you were convicted of burglary of a building, a state jail felony, May 15th of 2015. And are those two prior convictions true?
Yes.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I do.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Right.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Get caught up here. All right, sir, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. And cause number 25, DCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find those two prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those two cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. And I will sign that dismissal now in cause number 25 DCCR 1916. All right. You can go back with the bailiff.
Right.
So, I mean, Mr. LeBlanc, you've done so well. I mean, better than most you've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand? Ahmad LeBlanc.
Sitting here thinking I didn't notice a nice young new probation officer.
All right. Are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3 in a motion to adjudicate and probation for possession of a controlled substance, first degree felony. That's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
Have your
Any additions or corrections to the report?
None from defense.
only any additional that Ms. Shagwa may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge?
January 28th, Your Honor.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail and this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January 20th, he hired me and then surrendered to the court. Your Honor, his mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program, and another drug assessment, and we would ask that the court follow that alternative.
Ms. Malfino?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the drop program.
Anything to add that's not in that updated report from probation?
I mean,
So, I mean, Mr. LeBlanc, you've done so well. I mean, better than most you've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true, find sufficient evidence to find you guilty, and revoke your probation. But I'm not going to do that today. I think you've come a long way. You're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be required to enroll in and pay for it and successfully complete the Texas Drug Education offender program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this was an agreement. So you do have some rights to appeal. You can talk to Mr. Lane about that. And I need you guys to sign this, Mr. Lane, please. But you'll be released, and the first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right.
And just like that, the courtroom falls silent. 2 outcomes, 2 very different paths, but both sealed by prior choices. The judge didn't just deliver a sentence, he delivered a message. Now the real question is this: was it justice served? Or just the system doing its job with no room for mercy?